My son is now 20 years of age, so this question of guardianship is now long past. But I remember my wife and I discussing this at length in the terrible situation that both parents are dead, leaving orphan children behind is a really tough question. So in my case, because I don't have any children under 18 years of age, I'd press no and press next and move to the next question. But if you have children under 18 years of age, we need to really give some thought to that as to who will look after the children. Now, just be aware that in order for the children to be an orphan, or your child or children to be an orphan, both parents have to be dead. So if the father or mother is still alive, you die, they're not orphans. This clause will generally not operate. Of course, the court will always act in the best interest of the children, which brings us to this question about suggest a guardian. So you, in your will, are going to say who you'd like to look after your child or children while they're minors. That generally is only up to 16, because at 16, believe it or not, at 16, the children in Australia can leave home without your permission. I know it's kind of amazing. But we still like putting a guardianship clause in the will even up to 18. We find it's the best interest for the children. The children will often read the will and be involved in it and move to the auntie or uncle, even though they might be 16 or 17 years of age. Now, some people will say that it's a waste of time to add guardianship into the will. And I just want to explain why they would have said that. It's because the court can override the wishes in your will, the guardianship clause in your will. But gee, that rarely ever happens. Since I've been practicing since 1988 in this area of law, there's only been one situation where the court has overridden it, and that is where the parent suggested that the guardianship be different for one child to the other child. So basically the children would be separated. The courts are not going to do that. Other than that, I've always found that the courts will follow the direction of the will maker. This interesting about stopping family feuds. One of the things that amazes me as a parent is how wonderful it is when, well, I wouldn't use the word wonderful, but how loving it is if parents die, how relatives, neighbours and friends all come to protect the little tiny tots. And it's important at that point to have a public document like a will, because once you lodge your will for probate, it becomes a public document. Channel 7 can get a copy of it. Ex-spouses can get a copy of it. Nothing you can do about it. So it's important to give notice to the world who you would like to be guardian of your orphan children. Now, should you appoint one guardian or two or four? So often if you have for example, you might just appoint your parents, or you may well appoint all the grandchildren or the grandchildren's grandparents. So you might appoint four. It's your call. Now, in this instance here, you can appoint an uncle and an aunt and her husband, for example, and the brother and his wife. So there's the appointment of four people. Guardians have the day-to-day custody of the children. Guardians have the right to decide where the children live, who they live with, and their religion. But they may not have the day-to-day custody of the children. And the person with the custody decides how to get the children out of bed, not looking at their iPads, and put on the right colour socks and get them to school. So the guardians may not necessarily be the people holding the custody of the children. It's a decision for the guardians. Now, another question is, should we appoint smart people to be guardians of your children, people that are proficient in money or seem to be important people in society? And the answer is That's not the test. The test is who loves your children. That's the important thing. And it's even the courts follow that. They follow the heart rule rather than the head rule. What's in the best interests of the child? That's the number one requirement for everyone. If you go back to, we're going to talk about the maintenance trusts in a will, which we're going to discuss in a minute. You have power, the guardians have power to be given money, but it can only be used in the best interests of the child. Everything's about that one test. What is in the best interests of the child? And you can die with some comfort knowing that at all times society, the family court, and every person that touches and concerns your child or children have to keep that in mind. So over time, our law firm suggests 3 questions to ask when you're picking your guardian. Firstly, the vibe. I think that comes from a TV or a movie. What's the vibe? We're looking for someone that will understand your belief system. We're not going to pick a guardian who doesn't have the belief system. 2, can they physically look after the child? Can they run after a toddler? And maybe your parents at 80 years of age are not in that position yet, or moved on from that position. So work out what date your children will turn 18, convert that into how old your parents will be on that date. And if they're 90 years of age, that may not be the best people to be the guardian of the, or not be the sole guardians. Maybe you might pick your parents and your brother and his wife. And also you need to talk to your guardian. It's a massive life-altering. I see my solicitors have typed in the word burden in this hint, and I think it's a bit harsh. Not a burden. Looking after the child, your orphan children, is a privilege. But we don't want to surprise anyone with the role of, you've got to talk to them before you put them in the will. So there, read that hint and give it some thought. Now, Australia is a country of migrants. So my dad was born in England. My mother's parents were born in the UK, and my wife's parents, both of them born in Italy. So we're a family of migrants, and it might be the case that the best guardians are actually not living in Australia at the moment. Be careful. Because you've named a guardian does not give them the right to get to be able to reside in Australia. Department of Home Affairs does not grant permanent residency or long-term visas. Obviously, your guardians could fly into Australia and on your coin. The executors can give them money to fly in because that's in the best interests of your orphan children. Fly to Australia temporarily. But think about 2 things. If you've only appointed overseas guardians, it could be the case that they leave Australia forever to go back to their country, and that's problematic for us. And I don't know how to say this without sounding racially discriminatory, but I kind of think, and I've just spent a number of months with some family relatives in Europe, and they're desperate to come to Australia. Which they call Americano, and we are blessed. We are blessed that our great-grandparents or grandparents or parents or yourself as migrants escaped wherever we came from and came to Australia. It's generally a better place than where our ancestors have come from. Please don't take that the wrong way. And you may not want your children to leave Australia. It's very safe. It's much safer than Great Britain and America. They've had civil wars. We've never had a civil war. We're a much more stable country than Great Britain and America. The other question is that if the guardians come to Australia, it's only for a short period of time. So if you are going to pick out guardians, maybe you should have at least one guardian who is resident in Australia or has the right to be resident in Australia. But bear in mind that the guardian looks after as a legal authority, the big pitch decision, but the custody, the worker bee, makes sure the children get to bed by 8 p.m. that night. Now, the next thing is you've got a lot to say about how you want your children brought up. And you make that decision every single morning you get out of bed. And you'll die with that thought, because what do we do as parents but always think about children? Even if your children are 60 years or 70 years of age, we still think about what's in the best interests and we want the best for them. So you've got a long story to tell, a long story of proud heritage, of your religious beliefs, of things you did and things you want your children to do. But that should not go in the will. The will's a dry document. Also, it adds too much complexity, so don't put advice in the will. It's not binding anyway. It becomes a public record and it causes delay because of complexity. Instead, consider letters of wishes. So in a letter of wish, you can write, there's that word, the vibe again. I don't really approve of that word, but anyway, you can write what's in your heart. It's a private matter, and it gives the guardians some direction. They don't have to follow it because they have a higher duty to, remember what it was? The higher duty that the guardian has, the same as the court, to act in your children's best interest. So it might be the case that it's appropriate for the child to no longer go to a state school but go to a religious school, or might be appropriate that children leave their private school to go back into another type of school, or might be better in the children's interest that they stay in the parent's home, the dead parent's home, and that money be given to the guardians to stay in the house, even though they may not be what you wanted to do. Now, finally, what if you've appointed a guardian, but they can't do the job because they're dead or whatever? You should not use a substitute clause in a guardianship. You must not do it. It doesn't work. It adds huge complexity with the courts and the bank and the school. If you've got Uncle Harry and his wife Mavis, and if they can't do it, then two others, add all four in. Don't pick up substitutes. Don't do substitutes. So for me, I'm going to press no because I no longer have a child under 18. If you do, you'll type in, there's Uncle Harry, Vernon Bus. And I'm going to put in 4. So I'm going to put in their address, add another, add a third one, and add a 4th one. So I'm going to have 4. I'm going to complete 4 guardians. It's a big question, particularly if you're, it's just a big question. So I wish you well on looking at who will look after your children if they're orphans, and please feel free to telephone the law firm. We're here to give advice, and that advice is free. And remember, after you've built the will, you can then update it for free, and your will comes with free advice. So if you do die, we will speak to the guardians at no charge. We'll speak to your executors at no charge. Same with the power of attorneys. If you become of unsound, which we're going to build in a little while, if you become of unsound mind, then we will help the people that hold the power of attorney. We will explain to your executors how to get a grant of probate for free. And to their lawyer, their executors, their financial advisors, and their accountant, we're there to stand to help the family. The next thing we're going to look at is the opposite of guardians, and that is people that can challenge your will.